Good afternoon, all. Can you hear me? Great stuff. You're all very welcome to today's webinar on the EU Deforestation Regulation. As you know, there's been a lot of different developments over the last number of months, and the importance of today really is to give you a very brief update on some of those simplifications which have been proposed over the last number of weeks. This webinar is being recorded, so basically you can watch back at a later date. We'd like to thank you for your contributions over the last number of months. And today I'm joined by my colleagues on the line, Patrick Nulty, Colin Gallagher, Michael Gleeson, Ger Fox, and other colleagues in DAFM. And we'll try and answer as many questions as we can where possible. And I suppose the focus of today is supposed to confirm with yourselves really that, you know, we had a lot of simplifications being proposed by stakeholders, been lots of very constructive engagement over the last 12 months, which has been really beneficial. And the Commission have listened to those simplifications, and we have now a number of proposals which will be sort of voted on and accepted in the coming days. And again, it's quite important that these simplifications will really make things a lot more easier in relation to the implementation of the EU Deforestation Regulation. All the work you've done over the last while has been very important because it helps to identify those deforestation-free supply chains. So that's positive and beneficial. And certainly the 12-month extension which has been provided for now will give you more time to ensure that basically you're ready to implement the EU Deforestation Regulation. So without further ado, I'll pass you over to my colleague Patrick Nulty, who will give us a very brief update on where we currently are and also reflect on some of the discussions that happened this morning on the EU Deforestation Regulation. Over to you, Patrick.
Thank you very much, Fergus, and good afternoon to everybody. You're very welcome to this webinar. My presentation is going to focus on the contents of the provisional political agreement between the European Council and the European Parliament with respect to amending legislation in regard to the EU Deforestation Regulation. Can I just confirm that you can see the presentation and you can hear me clearly?
Yeah, we can see the presentation and hear you.
Great, thank you. So just to give a little bit of background, as many of you will recall, the EU Deforestation Regulation entered into force in June 2023 with the aim of ensuring that certain commodities, cattle, coffee, oil, palm, soil, rubber and wood and their derived products that were placed on or exported from the EU market did not cause deforestation or forest degradation. Now, initially, the provisions of this regulation were due to apply from the 30th of December 2024, but following concerns raised by member states, third countries and operators and traders, many of you who will be on the call today, an initial postponement of 12 months was agreed. In September 2025, the Environment Commissioner Roswell indicated that the Commission had concerns about the capacity of the information system built by the European Commission to cope with the volume of likely due diligence statements that would be submitted. We've had engagements both bilaterally and through webinars like this with stakeholders all across the spectrum of products and commodities, and we've taken on board your feedback and communicated that to the Commission, as has been the case right across the European Union. And all of those issues and challenges that operators and traders and representative groups such as yourselves on this call were facing have fed into the dialogue around what simplification might look like. So in recent weeks and months, the timeline of events has moved extremely rapidly. So on the 21st of October, the European Commission published draft legislation aimed at simplification. This draft was subject of extensive negotiation between EU member states, and on the 19th of November, agreement was reached on a revised text that went further than the initial Commission proposal with additional simplifications, many of which you would have been advocating for. A week later, the European Parliament also approved the draft text with simplifications, and the two texts, while being similar, were not identical. This triggered a process called trilogues, whereby the two institutions, the Parliament and the Council, negotiated to converge the two alternative texts and reach a political agreement on a final draft simplification text. That agreement was reached on the 4th of December, and it was confirmed yesterday that the European Council would approve the agreement through a written procedure next week, and there would also be a vote of the plenary session of the European Parliament on the 17th of December next week. When those two approvals are formally signed off by the two institutions, the final draft regulation will be published in the official journal of the European Union and become law. So, what are the key simplifications that this draft political agreement proposes? Firstly, it involves an additional year for the entry into application of the regulation, which means that the regulation will only apply to large and medium operators from the 30th of December 2026 and from the 30th of June 2027 for micro and small operators. There is an exception to this in the case of micro and small operators producing or trading in wood products presently subject to the EU timber regulation, and the entry into application date for them will be the 30th of December 2026, the same date as the large and medium operators. The simplifications involve significant streamlined obligations for downstream operators and traders. There is no need to submit due diligence statements or pass on reference numbers. The only passing on of a reference number happens at the very start of the supply chain from the primary producer or the first placer of the product on the union market to the next entity in the supply chain. There's no further passing on of reference numbers. There is a new category of operator created called micro and small primary operators. They must be based in low-risk designated countries, and they must harvest or produce the product themselves. And I'll discuss this new category in greater detail shortly, but it essentially focuses on farmers and forest owners. Books, newspapers, and printed material have been removed from the scope of the regulation, and the EU deforestation will be reviewed in its entirety in 2030. There will be a shorter report produced by the European Commission no later than the 30th of April 2026, which they will submit to the European Council and the European Parliament for their consideration. So taking the first simplification, the new micro and small primary operator. As I mentioned, they must be located in low-risk designated countries, and they must sell their goods directly onto the EU market. The European Commission estimates that this category will cover 95% of primary producers, 95% of farmers and forest owners. The provisions with regard to whether you reach this category have also been loosened for micro and small businesses, meaning that only 2 of the 3 criteria in the accounting directive need to be met. There will be a requirement to either submit a one-time only simplified declaration to the European Union's information system, or where the information is already retained on a system or database established under union law or under the national legislation of a member state, that can also be submitted to the European Union's information system directly and a verification number can be then provided to each small and micro primary operator. Also, geolocation is no longer compulsory for the micro and small primary operator, and a postal address of all plots of land on which the products were harvested can be provided should they so wish as an alternative. Thank you. Now, moving on to downstream operators, and this will be the new Article 5 of the revised regulation. The obligation and responsibility for submitting the required due diligence statement will fall exclusively on the operators who first place the product on the market. This is really crucial. Downstream operators and traders will no longer be required to submit due diligence statements or exercise due diligence. Non-SME downstream operators and traders must still register on the information system, but there will only be one due diligence statement required at the start of the supply chain. If a downstream operator or trader does become aware of concerns around a non-compliant product, they are still required to share those concerns with the competent authority. There is no requirement for downstream operators to make available to customs due diligence reference numbers or a unique identifier when exporting a relevant product. They will instead be able to insert a tariff code exemption. The first entity in the supply chain who buys the product does need to retain some elements of information, such as the name, registered trademark, addresses, and reference number of the operator who supplied them. But as I must stress, it is only the first entity after the primary producer or the first placer on the market who needs to do that. Nobody else will be required to do that. So this table just gives an illustration of the duties and obligations, distinguishing between small and micro enterprises and non-small and micro enterprises, including the new category of micro and small primary operator, confirming that the downstream operator and trader does not need to exercise due diligence any longer or submit due diligence statements. Now, looking at the review clause now inserted into the regulation, all previous reviews have been amalgamated into one holistic review that will take place in 2030. The European Commission confirmed this morning at a meeting of the multi-stakeholder platform on deforestation, which is not only attended by competent authorities and member states, but also by third countries and also by stakeholder organizations, many of which some of you will be affiliated to or members of. The European Commission confirmed that in early 2026, they will be publishing a revised official guidance note and revised frequently asked questions. And they have invited stakeholders to submit any questions or feedback or queries they have that they feel need to be addressed in these documents that will be published to the European Commission. And you can see on the screen there the email address env-deforestation@ec.europa.eu. So we would strongly encourage you to submit your feedback, your queries and your questions that you think the Commission still need to address into that process. And that needs to be done no later than the 31st of January 2026. So just to re-emphasize, because I know this is really important, the entry into application dates when political agreement is formally approved. Large and medium operators and traders, the regulation applies from the 30th of December 2026. It is the 30th of June 27 for micro and small enterprises except for those micro and small enterprises producing or trading in wood products, presently subject to the EU timber regulation. And there is a new Annex 3 of the draft regulation that sets out the small number of details that micro or small primary operators would be required to submit in their once-off declaration, should they wish to do so, to the Commission's information system, while also noting that there is another potential mechanism to share that information. So that concludes my presentation. That's the key elements of the proposed Commission simplifications. I would invite my colleague Michael Gleeson from our Beef and Sheep Meat Division. If Michael, you would like to add anything to what I've said thus far before we throw the call back to our chairperson Fergus Moore and deal with any potential questions.
Yeah, thanks, Patrick. I'll just make a few random comments maybe. There's a couple of questions in there in chat, including one about the low-risk countries. So Ireland's a low-risk country. It's the same categorization as was announced previously. So there's no plans to change that in the near term anyway. So that's just to answer that question. And I take it, Fergus, you'll pick up on there's about 2 or 3 more after that, including one from Judy again. Sorry, it's a different person actually. So apologies if what you call, Patrick emphasised it was a very dynamic, fast-moving situation over the last couple of months. So apologies if people felt they hadn't been kept fully updated on it. Basically, what we have now is the outcome of a political process, and we couldn't be sure, although we had made a reasonable judgment, or our assessment of the situation was that the new amended rules would in fact be brought into force, and the Commission expects that that's what would happen with the parliamentary vote, the European parliamentary vote next week. We did try to, and sorry, on the beef and cattle side, my team did try to answer any queries that came in as they came in, and at the same time try to give people an idea of the bigger picture, given the fact that it wasn't entirely definitive at that stage. So just a couple of points that strike me, as Patrick emphasised, then farmers will come into the micro and small and micro producers category, and then we'll now have to do a simplified once-off declaration as distinct from a due diligence statement, and that's actually set out in Annex 3 of the amending reg, and we can talk about that maybe a bit more later on. Essentially, the Commission's information system was set up to deal with the current rules, i.e. the 2023 rules, before enactment, so they will have to modify their own system, including putting in some functionality as regards these simplified declarations and also APIs. I think it's as well to note that the Commission were quite adamant today that that report they will be sending to the other institutions, i.e. the Council and Parliament, by the end of April. There'll be no public consultation in that, and they were very anxious to emphasise that while it will take account of feedback on the FAQs, etc., which Patrick has already mentioned, and for which deadline is the end of January, it's within the current provisional, the parameters of the current provisionally agreed text. So they don't anticipate any further simplifications at this stage. I strongly suspect they might have liked to have got rid of it, but it's still in the legislation, and they only envisage making a report to the other institutions. We have a deadline there for the FAQs, as I mentioned, and just to further elaborate on Patrick's point there, if bodies are making submissions to the Commission on this or asking questions, it might be as well to keep the relevant section of the department notified also, because that would help us, particularly if messages need to be reinforced, etc. So at this stage, the Commission were saying that for the last couple of months, because of the fast-moving nature of events, they spent most of the time stock taking and modifying the amended text. And what that means in practice then is that essentially they haven't had a lot of time to tease out the practical implications of implementation on the ground. For example, farmers will no longer do a DDS. They will do the simplified declaration in Annex 3 of it. But there was questions asked today for which they didn't necessarily have the answers about how do you estimate now it's meant to be once off, but how do you estimate the volume of forestry or the number of cattle? Well, they wanted in weight to be put in that, and that again has to be teased out through the FAQs, so they don't necessarily have all the answers on that. And we were asking them also, since the farmer is the first person to put is the first person placing the animal on the market, for example, then if that involves it being purchased by another farmer, are they then considered a downstream operator or treated as a downstream operator? And they are the person then who has to look for proof, i.e. declaration identifier, when those animals are put on the market. Obviously, the first placing on the market means that it applies only to birth herd of animals, of which, according to last year's AIM bovine statistics report, there were about 63,000 in total. So those are questions that still remained to be answered. However, for the meat processors, then clearly there's no cliff edge from the end of this year, and the transition period is just simply extended. However, by this time next year, or 30th of December next year, there will be very little for them to do at that stage either. They should be granted a tariff, exporters, which a lot of processors are, should be granted a tariff exemption, and they won't necessarily be submitting a DDS reference themselves. We'll get we'll get the slides from the Commission, and obviously we'll circulate those once they're available. At this stage, I think that's enough by way of preliminary remarks. I should just point out as well, I know that some meat companies were under pressure from their customers or whatever to be active from the start of this year, notwithstanding the fact that it was entirely likely it was going to be postponed. So essentially retailers or whatever have to have regard to what the law states. So the meat companies do not need to provide DDSs, but even when they're being asked now, they wouldn't have needed to do so either. Essentially, they will be able to comply with the new laws because, as Patrick pointed out, most of the simplifications that we would have wanted to make the rules workable have in effect been conceded at this stage. They weren't in the original Commission simplification, but further negotiations, particularly at member state level, ensured that the Council position was one that I think we can work with. So at that stage, Fergus, I'll let you.
Yeah. That's great, Michael and Patrick. Thanks very much for that. That's been a very sort of high-level overview of where things are at. And I say the position has been quite moving quite fast over the last number of weeks. I've got to say at the start, really, there's a questions and answer tab box which people can put in their questions. We'll try and answer the majority of the questions we can today. And as Patrick has mentioned, if you've got any specific questions you want clarification, there is that EU email address which Patrick read out. And of course, we will share this presentation after the meeting today. And if you would basically email that address, you will get clarification from the Commission. But certainly we'll try and answer many questions we can today. And obviously ourselves in the department are also available to take questions as well. Subsequently, our door is always open. There's a few questions come through there. There's one there from Julia Griffin, just about low-risk countries as per the benchmarking report. And I suppose, yes, there is a benchmarking report which is being prepared by the Commission, which basically ranks various countries into high, medium and low or negligible risk. And Ireland and the whole of the EU, for example, is in a low risk category. Other question which has come through there from Chloe Dillon. If a third-party retailer dealing directly with brands does not manufacture their own products, but imports products on behalf of a brand into the EU, is the brand or retailer the operator? I pass that to you, Patrick.
Yeah, thank you very much for that question. So going back to what I said initially, when you're importing a relevant product from outside the European Union, it is the first placer of the product on the union market who is the operator and who has to conduct the due diligence. And that is identified by the consignee on the customs declaration. That is already presently the case under the EU Timber Regulation, and that will continue to be the case under the EU Deforestation Regulation. So the importer is the consignee on the customs declaration, and they place the product on the EU market for the first time. I just might also add, Fergus, that this webinar will also be up on the department's website, gov.ie/EUDR, within the next couple of days as well, if people want to view it or share it.
Yeah, thanks, Patrick, for that. There's another question has come in from Teresa Sampio. If the regulation is postponed by 1 year, what will the new enforcement date be for our company? We are a small business and will be first to place a product on the market, while our customers may be large downstream operators or traders. In this case, would the enforcement date be for the micro small companies of the 30th of June 2027? Patrick again.
Yeah, I can answer that one. That would absolutely be the case. And if you then subsequently sell your product on to a larger or medium enterprise, they wouldn't be required to do due diligence. And if you were exporting or importing, for example, there would be a tariff code exemption to get a customs declaration. As I mentioned in the presentation, the only exemption in relation to that is for products presently covered by the EU Timber Regulation, in which case all operators and all traders for those products, the entry into application date would be the 30th of December 2026. So for small businesses, it's the 30th of June 27, except in the case of wood, where it's the 30th of December 26.
Sorry, just one thing to add to that. Sorry, Fergus. Just one thing to add to that, Patrick. The directive, the 2023 directive, lays out the thresholds for small, medium, large, and large and medium-sized businesses, the definitions of them. So once you're certain that you're come within that those definitions and that you've checked the directive, then it is as Patrick says. So just beware of the directive.
Yeah, thanks, Michael, for that. And then the question from Judy Walsh: can you advise of the new obligations? Can you advise the new obligations for a non-SME trader receiving goods from a UK-based supplier who imports the products into Ireland before delivering to the non-SME trader? We were previously advised by DAFM that the Article 7 obligations were covered by ascertaining due diligence using the DDS used to import the goods. The proposal removes the ability to ascertain due diligence. And again, Patrick, for you.
Yeah, so again, this relates to imports. So the first placer on the market is the company that needs to do the due diligence. Then the company next in line in the supply chain, they will have the due diligence reference number passed on to them that they need to retain. They do not need to exercise due diligence if they are a downstream operator or trader. All they need to do is retain the reference number, and only in a situation where they are the first receiver, purchaser of the product. Any other trader further along the supply chain does not need to either retain a due diligence reference number or exercise due diligence. So that's a major simplification for operators and traders further along the supply chain.
That's great. Thanks for that, Patrick. Next question is from Stephen O'Ree. It says, do importers who are also downstream operators still need to provide DDS reference numbers on our customs declaration forms? Again, Patrick.
Yeah, that's a similar question to, I think, one of the previous questions. And again, I would just stress that when you're importing a product that this regulation will apply to from outside the European Union, and you are the company that is placing the product on the market for the first time, then you are an operator and you would be required to submit a due diligence statement and exercise due diligence. So that's where you are importing a product from outside the European Union. And again, that's presently the case under the EU Timber Regulation.
Yeah, thanks, Patrick. The next question we have is from Stephen Farrell, and maybe one for you, Michael. It says, from a beef point of view, is first to market the first sale of a commodity HS code or just the animal?
Yeah, what you call it, we myself and Patrick had a discussion about this. Our understanding at the moment is it's the animal, and as you know previously, Stephen, you had to the processor had to do the DDS because they were converting it into beef, but that no longer appears to be the case. Patrick, do you want to add anything to that?
Yeah, I mean, that's absolutely correct. In our read and our understanding, as we've been provided with it and as the regulation sets out, the first placing on the market is the cattle. And then if a product undergoes a substantial transformation further along the supply chain, when due diligence has already been exercised on that product upstream, so there's already been due diligence done on it. More often than not, in the case of cattle, if produced inside the European Union by the new micro and small primary operator. So there's no need for duplication of functions, if you like, further down the supply chain.
Thanks, Patrick.
Which is exactly what, sorry, yeah, Fergus, which is exactly what would have been happening there. And that just pointed to the kind of the very onerous burden that was placed on supply chain actors before, because as Patrick said, even previously, they would have been, the animals would already have been cleared to enter the market, and yet merely because we were changing HS codes, it was felt another DDS was needed.
Yeah, thanks, Michael. The next question is from Stephen Ori again. It says, if a DDS reference number are needed on imports where we are a downstream operator, how can we obtain these from our EU supplier if they're also a downstream operator who has no obligation to collect? ? Can we use the same tariff code exemption as exporters?
Yeah, there is a frequently asked question that the European Commission produced on re-importing products, and some stakeholders sought clarification on that this morning. And the Commission said that they would provide that in the FAQs and the new guidance note. So that is one. Maybe if you'd like to provide us that question in writing, and maybe also provide it to the European Commission, just to tease that one out a little bit more. But essentially, there's the same reference number for re-importing the same product should be okay, or a tariff code exemption should be okay. But that's something that I think we would like to see confirmed by the European Commission in their revised guidance.
Thanks, Patrick. The next question is from Stephen Connolly. He says, apologies, I missed the start. Will we need to supply geolocations on our DDS's number? And maybe before I let Patrick answer that question, just to say is that the Department of Agriculture have been working quite hard in the last number of months, and we now have provided geolocation reference numbers for all forest parcels associated with a felling license application, and these are currently available for download from the department's open source felling licensing viewer. And also we have a lot of data as well in our own DAFM systems, and again we can provide geolocation information in relation to farm holdings. But certainly a lot of work has gone on in the background to make geolocation information available, but there's also systems that would allow you to do that yourself as well if required. But maybe Patrick, do you want to just answer a question in general about DDSs and geolocations?
Yeah, I think particularly, you know, in the case of imports from third countries, geolocation is still required under the regulation. What I would say is that the Commission acknowledged this morning that getting geolocation information has proved challenging for companies, particularly in certain operating in certain locations. But presently, yes, if you're importing a relevant product from a third country and placing it on the EU market, you will need to provide geolocation as part of your exercise of due diligence.
Thanks, Patrick. The next question is there from Claire Grimstead. It says, hello, thank you for the concise overview of the simplifications. Given the Parliament and the Council have both approved the delay simplification, do we still need to wait until the 17th of December before recognising a formal delay? And I suppose all we can say there is it's a political decision, but I mean, all the indications are from this morning is that it will happen and there will be a 12-month delay. I don't know, Patrick, if you want to reinforce that.
What I can tell you is what the European Commission said this morning publicly at the multi-stakeholder platform, which was that they were very confident that the political agreement between the Parliament and the Council would be approved next week. The short answer to the question is yes, we do, because European legislation does not become law until it's published formally in the official journal of the European Union. So I think we just need to sit tight and wait the formal approval from the Council and the Parliament, which I think the Commission have said is very, very likely. And as you will recall from my presentation, both institutions have already agreed these presentations, but it's just a case of allowing due process to run its course without preempting it.
Yeah, thanks, Patrick. But all the signs are that it's going to happen. So again, we can't be definitive, but I mean, you can read between the lines that it is going to happen. There'll be a 12-month delay, and we can't say any more than that. The next question there is from John Durkin. Will DAFA be supplying geolocation information for beef farmers to operators so operators can produce a DDS? And again, I think I said before is that, you know, DAFA have a lot of information in our current databases, and this is probably one of the questions and the feedback we would have given from all member states is that where we have lots of information already collected from our beef farmers and from our forest owners, we could try and use that information to make this, I suppose, implementation of the EUDR more simple than it was originally proposed. But from a DAFA perspective, I suppose, Michael, yes, we will be able to provide geolocation information on farm holdings, and we will work on that in the next number of months. Do you want to add anything, Michael?
Yeah, thanks. Well, as you know, Fergus, from our own internal discussions, we were working on a two-phase IT solution. The first phase, obviously, being to help the process to meet what the original deadline at the end of this year. And then we paused that work before rolling it out because, as I said, our judgment was that it wouldn't be necessary to proceed any further with that. And then the second part of it would be to look at what farmers would need to comply with their legal obligations. And as Patrick actually pointed out, although I don't think necessarily that a lot of farmers will go with this, the new amended regs allow for postal addresses of plots of land or establishments. So certainly, yes, we have geolocation data, and we'll now have to take up in the new year, consulting with IT colleagues about what sort of IT solution we might bring forward, talk to stakeholders about, and the timelines for doing that. And of course, the situation, as you know, is slightly different on the forestry side.
Yeah, thanks, Sam. Michael, next question is from Alison Heaney. Hi, I'm a large downstream operator. Once I get the DDS number from my upstream operator, do I have to pass on the DDS number onto my customer? Give that to you, Patrick?
No, you don't.
You don't. Okay, maybe I missed a question there. I missed a question from Magda Rachel. Hi, could you please advise if we manufacture products that are not listed in the EUDR annex, but we use materials that are listed in the annex, are we still required to carry out due diligence checks on those inputs under the regulation? With you, Patrick?
Yeah, so again, the regulation applies to products in the annex based on HS code. So if you place products on the EU market or produce those products within the union market and make them available for sale, then the regulation will apply to you. So that's whether it will apply or not. It's based on HS code. So for example, if you imported, let's say, wood or cocoa and made a chocolate bar or made furniture, the regulation would apply to you on that cocoa or on that wood that you imported. So it's based on HS code, and it's based on who places the product on the market, who has to exercise the due diligence.
Thanks, Patrick, for that. The next question we have is from Claire Grimstead. What will be the specific process for beef processors being able to share a DDS? I'll maybe pass you over to Michael for that one.
Right. Well, they may not necessarily have to share the DDS. The previous Commission proposals from October were very insistent that downstream operators had to pass information down along the supply chain. However, that has been removed from the current provisionally agreed regs. So my judgment is that that they don't necessarily have to provide DDS locations, or DDSs or locations for the downstream.
Yep, thanks, Michael, for that. Next question we have is from Quiva Buckley. Does the panel know if SBTI flag will also reduce requirements to keep in line with EU DR? I'm not too sure what that SBTI flag is referring to. I don't know if that rings a bell with anybody on the panel. Maybe
you could share that one in writing with us after the webinar, and we can try and get an answer for you.
Yeah, Quiva, you could probably email us directly on our EDR email address. We can answer that question directly. Next question is from Finbar Curran. There was a delegated act in April 25 seeking feedback on a proposed clarification in the Annex Point 2 in reference to cask barrels and whiskey barrels. Just looking here on my screen here, apologies. Yeah, so the question is, has this simplification been passed on, or will this fall into the overall simplifications to be agreed by the 30th of April 2026? Thanks for the update. Do you want to answer that question, Patrick?
Yeah, no, thanks for that question, Finbar. The Commission confirmed this morning at the multi-stakeholder platform that the delegated act would still have to come into law. And so I know this was an issue that was raised by stakeholders earlier this year, and my understanding is that a resolution was found based on the fact that those cask barrels, for example, are second-hand products or could be understood as second-hand products. So my understanding is that that issue has been resolved to the satisfaction of stakeholders. But if you'd like to again follow up with us with an email, we can tease that out with you.
Thanks, Patrick, for that. Next question is from John Roach. Where a forest manager company is buying timber from a grower and then selling it on to a number of sawmill customers, is the grower or the management company that will need to obtain the DDS number? Also, will one DDS number suffice if there are a number of different sawmill customers for the same timber harvest? And I suppose, John, that's a good question. I think, you know, from our perspective and discussions we've had, we have a lot of information, as you know, from our felling licensing database that we make that available in our systems. So from our perspective, we would see probably those forest owners doing a one-off declaration in relation to the timber they're going to harvest, and they'll make an estimate of the annual timber they will actually produce on a yearly basis, and they will get a reference number from DAFM. It'll be a one-time reference number that they can supply to those particular sawmills when they actually sell their product. So I think from a forest owner's perspective, the simplifications have been really has made it very, very simple, and certainly we'll be engaging with yourselves in the coming months on how that would work. But certainly, yeah, a one-off declaration you would see from our 24,000 forest owners. We would leverage all the information we have in our existing felling licensing database as well. So all the information you require is already currently available from our felling licensing viewer. The next question we have is, if the product has been placed on the EU market to be processed and then sent to the UK, and then the product is re-imported and placed back on the EU market, how do the new rules apply? And that's from Rebecca. Maybe Patrick, might answer that one?
Yeah, so again, I'd refer you, Rebecca, to the FAQ on the re-importing of products. There will be no need to exercise due diligence twice, and the re-importer will be considered a downstream operator. So therefore, there's no due diligence obligation on them.
And just to add to that, Patrick. I think that was actually clarified today, wasn't it? That the Commission said there was no change to that particular rule as regards re-importing, because it's a big issue on the beef in the beef industry. You know, product being sent to the UK and then being re-imported again.
Yeah, thanks for that. A question from Claire Hayden. With wood products from a customs point of view, is there going to be any requirements to submit anything to the likes of DAFM with FLECT cert submissions, or will that also be exempted? For you, Patrick, there?
Yeah, so a FLECT license in and of itself does not constitute compliance with the EU Deforestation Regulation, because as we transition from the EU Timber Regulation to the EU Deforestation Regulation, we're moving from legality to sustainability, if you like. So a FLECT license in and of itself would not constitute compliance with the Deforestation Regulation, but it would obviously be a very important piece of evidence to provide in your due diligence, and a demonstration of meeting the legality component of your due diligence system.
Thanks, Patrick. The next question there is from Gio Onofri. It says, as per your earlier query, we are an importer, distributor of product coming from the EU into Ireland. Are we, the distributor, still considered to be the operator or the brand principal who manufactures the product? I don't know, Patrick, if you can answer that question.
Yeah, without knowing the exact supply chain details, my instinct is that yes, if you are the consignee, you're importing the product, making it available for sale on the EU market, and then selling it on to companies further down the supply chain. So you would be the consignee on the customs declaration and therefore the operator. As I say, that would be based by a general comment without knowing the detail of your particular supply chain.
That's great. Thanks for that, Patrick. Question from Judy Walsh. What type of evidence is needed to verify that my suppliers are micro and small and have a deferred application date? Patrick?
That's a question that came up this morning as well. They will obviously have a reference number from either the one-time declaration they submit to the information system, or the one that they've been provided a verification number through the provision of detail available to member states. So they will be able to provide you with that reference number. And also, if you recall from my presentation, downstream operators are still required to register on the Commission's information system as well. But primarily, it will be through the sharing of that reference number, and that would be the primary way to show that they're compliant. It's their obligation, it's their legal obligation to ensure that they are declaring their category of business in the correct way, and that's still a formal legal undertaking on their behalf.
That's great. Thanks for that, Patrick. I suppose, conscious of time as well, we'll try and rattle through as many of these questions as we possibly can. But also, say we have that EU email address that Patrick put up earlier on, that you can certainly fire your questions straight to those that email address to get confirmation or clarification. But the next question we have is from Aaron Eilish. Is, can you share that 2023 directive with those who require it after this call? What I would say is, Aaron, is on our Department of Agriculture website, there's loads of links there and loads of information that basically gives you the appropriate links to the Commission website. So we'll certainly we can reshare that information after that call.
Sorry,
when you say, sorry?
Yeah,
yes,
it's Commission Delegated Directive EU 2023/2775.
Okay, thanks for that, Michael. Next question is from Luna Fagundes. It says, when you say the first to place on the market, is this the first EU-based company that places on the market? The
it's the first company to place the product on the market. Yeah.
Okay. Then John Coonahan, it says, how will this impact goods moving into Northern Ireland from Great Britain and then onward onto the Republic of Ireland for both large and small businesses? I'll pass you over to Patrick on that one.
Yeah, so I mean, the question of whether the regulation will apply in Northern Ireland is a matter for discussion between the British government and the European Commission. It's the view of the European Commission that the regulation does apply in Northern Ireland, and we really can't go beyond that today, other than to say it's a matter of bilateral discussion between the British government and the European Commission. But the proposed deferral does create breathing space to provide clarity on that issue, I think, which many stakeholders would be very keen to see.
Okay, thanks, Patrick. I think Jen Ward is the next question, but I think we've probably answered that question before. So moving products in and out of the EU. I might move on to the next question, actually, which is from Paul Hamilton. If goods are produced in the UK and come into Northern Ireland for sale in the Republic of Ireland, is the Northern Ireland company the first placer on the EU market? That's probably a similar question, Patrick.
It's similar, yeah. I suppose the best way to answer that would be when there's if and when there's confirmation that the regulation applies in Northern Ireland. In theory, yes, they would be, but we just need to wait to see that discussion be played out or be resolved, if you like.
Yeah, thanks, Patrick. And probably one for Ger Fox, Ger from Patrick Cotter. It says, what about coffee? Is a coffee roaster is buying coffee from Brazil, Colombia, and Guatemala via an importer? Would a roaster be the downstream operator? Could you take that one, Ger?
Again, is it be an importer? So somebody else is importing it first and then passing it one step down the line. So that being the case, then the person who first imported it would be the operator and have to do the due diligence, and they would require then to be passing on the DDS to yourselves, and then you wouldn't have to pass it any further because it only moves one step down the line.
That's great, Ger. Thanks for that. Next question is from Julia Griffin. Product being shipped from the EU, Italy by downstream operators, traders to the UK, then sent to Ireland. It would not need a DDS reference as has already been placed on the EU market, question mark. Patrick?
Yes, that's correct. Again, I think what we might do is there's been quite a few questions around the re-importing of products. So we might just share the Commission's FAQ on re-importing of products as soon as we can and make that available to people. But that question has been addressed by the Commission where the same product is being exported and then re-imported into the Union. But we'll try to share that FAQ to colleagues on the call.
And sorry, notwithstanding the fact that the FAQs are going to be revised,
Yes.
we still think that advice will continue to apply.
Yeah, thanks for that, Michael. And certainly, I think at the end of this particular webinar, which we'll finish in about a few minutes' time, we will circulate all the documentations and links on this presentation. And certainly, I think I would encourage you to read the FAQs that are there, the clarifications which have come out from the Commission in recent days, and also there'll be more clarifications that will come out in the weeks ahead. But also, your opportunity is to email the Commission directly with some of these questions that you may have that we managed maybe not to get to today. Cassidy Sobey, next question is to clarify, let's say a finished bovine leather product such as a key chain is being imported into the EU for the first time. Does this need to follow EDR guidelines, or is it only the raw material stages that need to follow EDR guidance in accordance with the Annex 1, e.g. bovine leather hides? Is that one you could take there, Michael?
I could, but actually I'm not hugely familiar with the leather stuff. Patrick, can I ask you have a view on that?
Yeah, I jump in there, and again, it goes back to the HS codes. So if you're importing a relevant product that falls under one of the HS codes, then you will need to supply a due diligence statement and exercise due diligence. And now, obviously, there are some products that have the same HS code, and the regulation doesn't apply to them. So, for example, bamboo, but there's a tariff code exemption for that. So broadly speaking, if your product has a HS code that's in the annex, then the regulation will apply to you when you import it and place it on the European Union market.
And there's no change likely to be to those HS codes?
No.
Okay, thanks, Patrick. Stephanie Lodela has put a question in there. What are the responsibility of downstream operators when purchasing from SMEs? I think the FAQs and the information we have currently on the website actually outlines what that is. Does the EU Traces system conduct a deforestation analysis on geolocation provided, or is it just records that info. That's from Aaron. Do you want to take that, Patrick? It's a bit unclear.
The short answer is no, it doesn't. The competent authority will assess whether an operator is has a robust due diligence system and is able to conclude a negligible risk. So that's, if you like, the role of the competent authority to assess the information provided by the operator. Traces doesn't undertake tasks of that nature, although there are various mapping tools available both to operators and to competent authorities to examine.
Yeah, thanks, Patrick.
On that point, if the person is that was asking the question here, is the importer, then they're putting the product in the union market and therefore have to do the DDS. And as you know, part of the DDS is that you must satisfy yourself that the product is compliant.
Yeah.
So that's in addition to what Patrick has said about the competent authorities role. Okay.
Thanks for that, Michael. There's two more questions there I might take together from Stephen Farrell. It says, beef moving from the UK to the Republic of Ireland, EU, who needs to produce the DDS, and is it important, is the importer a record, is it importer of record on the custom forms? Who do we record on the custom forms? You want to tell him, Michael?
So Stephen, the processor here is the importer, because sorry, I don't understand what you just said, because they're importing stuff from the UK which hasn't gone out before. So then the obligation lies with the importer.
Okay, thanks for that. Just conscious of time.
Sorry, yeah. Let me know if you come back to me privately if you need more detail or whatever.
Yeah, we're just coming up on 3:30. I just want to confirm with Joe, I think our webinar will finish at 3:30. We've quite a lot of questions which have come in, which is certainly a lot of interest in relation to the simplifications that have been proposed. I don't think we're going to get a chance to go through them all. And what I would say is that some of these questions you've asked, I would refer to the FAQ questions that are already present there. And what I would do is, if you keep your questions, and if you email them to the nvdeforestation@eeceuropa.ie website that Patrick has, and we will share that information after this particular webinar. So what we'll do at the end of this webinar is we will circulate the email contact addresses for the Commission's email, which will hopefully inform the FAQs that are being developed. And we'll also circulate our Department of Agriculture specific email addresses in relation to the various commodities. And if there are any particular questions that you want us to address, please email us directly, and we can certainly take on board those particular questions and give a response. I think looking at our questions that have come through, a lot of questions are coming through, and a lot of them are very similar, which is positive. And certainly, I think the recording will be available online. We'll be able to post that on our website. But what I will say is to check in with the information that we will circulate. The Commission have produced a lot of documentation in the last couple of days, and they will do so over the coming weeks. So certainly keep your questions, post them to that EU NV Deforestation email address that will circulate after this webinar. If you have any particular specific questions in relation to the commodities which you want to ask of DAFM, please feel free to email DAFM directly, and we'll also provide those specific email addresses for you to contact us directly. I say the webinar will be available online, and certainly we thank you for your participation today, and we will certainly run more events early in the new year if that's required in relation to providing more clarifications. But certainly you will see a lot of information coming out in the next number of days from the Commission confirming that extension has taken place by 12 months, which certainly gives us a lot of breathing space for the next while. So thank you all, and thank you for our panelists for answering all those questions, and have a good Christmas, and certainly enjoy the 12-month extension and use it to, I suppose, continue the preparations that you've made over the last while. Thanks very much.